Hi, everyone. Welcome to episode 248 of the Immigration Lawyers Podcast, part of the Immigration Lawyers Toolbox. It's July 5th, and we're here for our monthly chat with Kevin A. Gregg about U.S. immigration with regards to court updates, PIA updates. Kevin being the pretty much the number one immigration podcast now with Immigration Review in wherever you find podcasts discussing in detail the hardcore analysis of immigration laws and news. Much more hardcore than me, especially when it comes to court cases. But we got our own genres and stuff. So I always like having a board to give it some stuff that I don't get into in particular. Before we start, I want to thank everyone who is reading the magazine for the Immigration Lawyers Toolbox. It's out at Immigration Lawyers Toolbox magazine, immigrationlawyerstoolbox.com/magazine. We have the new issue out. We're going to be finalizing stuff on it, but it's available if you want to check it out. But tons of information. If you're doing any type of case, really, you're going to find some really good just basic information about how to do it, both at a beginner, intermediate, and expert level. I'm really satisfied and proud of the work there. And I'm really thankful for the sponsors who helped bring this to you on the magazine. One was Argo.com, former immigration consular officers at embassies getting together to help people that want to go through the process, filling them in. Definitely reach out to Argo.com for information about them. Mandy Fearbacker's been on the show before. She's in charge there. Wonderful immigration lawyer and former consular officer. A lot of help. It's helped my clients as well. And also DocWise, obviously, who's always been a big supporter. You can get additional 10% off their annual plan by going to docwise.com/immigration-lawyers-podcast using the code Immigration Lawyers Podcast. They're a great service for all-in-one form software. They have all sorts of systems, so your office can do it all in one. They recently were purchased by MyCase, so much more integration happening if you do office management through MyCase or interested in purchasing one. Maybe jump on MyCase too. So it's a lot of extra benefits that come with them. docwise.com. Having said all that, thank you so much for Kevin coming on the show again. Great, Kevin.
My pleasure.
Good to see you.
It's my pleasure, John. And DocWise is sponsored my show as well, and I'm very fortunate and very thankful for that. And I also recommend them highly. And Argo is not a sponsor of my show, but I also recommend Argo highly. Mandy and the whole team. They've been a big help to us and our clients as well. So that's just coming from me. There's nothing to do with sponsorship. And I also want to say, and you're always saying such kind things about my show, and we just do different things, like I find, I don't know, I like the case law a lot, but some of the stuff that you do on your show, some of even the little things that you do, just promoting it out about process, I find immigration process, especially at the consulates, so confusing and so obtuse. And if any, the things that you do are very helpful there too. And it's of course not just at the consulates, and that's also what Argo does as well. But it's almost proceduralist, and they change so much. It's not even law. It's just what are they doing this month, and so that's just as important as knowing the categorical approach.
Yeah, I'm in the thick of it. So like the procedure stuff is just what I like to talk about, and it's just things that are annoying me. Like right now, this constant process case at the register. Every day I'm going back with the usvisainfo.com people. There's a mistake. They keep saying it's fixed. It's not fixed. I just recorded a Loom video of it saying, look, it's not fixed. Like, come on, this person, the interview's coming up. Just fix what you need to fix. But it just on the day-to-day basis, it's the grind. I'm like, oh, it's good stuff to talk about. Just so many different angles to this game in this area of law. So it's wonderful to have both. And really, if people are listening, they want to make their own podcast, don't hesitate. Just have good content. It's not too difficult nowadays to set up a podcast. It's inexpensive. It's just the time is the part about it. But there's a lot of benefits you get both on creating business and networking. You become a better immigration lawyer because you got to think about this stuff where you say it. So your quality of practice goes up. It's a win-win. So I wouldn't mind more immigration lawyers that are dedicated coming on, sharing this information because it just makes a better practice area.
All of that, although it is an amazing amount of work, and I don't know how you do it with children, but...
And that's where the 4 a.m. wake-up time comes in. It's gotten to a point where I tried to sleep in today because yesterday was just a tiring day. And I woke up, I'm like, well, I'm going to just lie here. I might as well just go to the office. And I just walked over to the office, which is my laundry room, and started
Yeah.
So let's get started. What kind of cases do we have this month?
Well, I'm making this a de facto show only about the last month's positive immigration decisions, right. And it won't always be all of the positive ones, but certainly only positive ones, because why talk about the negative? There's too much of that anyway. And so this month, There was actually a lot of interesting stuff in the crimmigration area, and I'm not going to get too in the weeds on it. Obviously, I do that on my podcast, but it's important to highlight. And I want to highlight the fact that the first one is coming from the Supreme Court, when the Supreme Court did so much that I personally don't agree with this term, and just last month, to be honest with you, including in immigration. I mean, the last month was so heavy for the Supreme Court. But the one decision that it did issue that would benefit non-citizens, including permitting the Biden administration to terminate MPP, is United States v. Taylor, which actually isn't in the immigration context at all. But it's in the categorical approach for the Armed Career Criminal Act context, which quite frankly sometimes comes up with the most favorable law for non-citizens, because the ACCA applies to citizens usually, and it's just so it seems that there's sometimes more empathy in that context. But it's the same categorical approach. Case after case has made that clear. So what the Supreme Court and circuits, but especially the Supreme Court, says in the ACCA context, very important to immigration. And what they said in United States v. Taylor is that attempted Hobbs Act robbery, which is federal robbery with a gun, I'm pretty sure, attempted Hobbs Act robbery is not a crime of violence because it's an attempt. It's not violent. There's no violent force with just an attempt, at least at the federal law, because what is required, and I think it's a significant step, is the substantial step is what is required to get an attempt conviction. So a substantial step towards robbery. That substantial step under federal law, it doesn't have to be violent. It's not even close. I think Justice Gorsuch was talking, and Justice Breyer were talking about a hypothetical where the person walks into a bank with like a letter that says your money or your life, and they get caught by the cops before anybody even knows what's going on. Yeah. That's a substantial step, but it's not violent. And I have a feeling that most states have similar requirements for an attempt type crime. So to me, United States v. Taylor seems to make it very difficult, if not impossible, for attempt crimes to be crimes of violence, aggravated felonies, which also would then potentially take them out of crimes of domestic violence, removable offenses, an attempt, because it doesn't require violent force. Now, there's a caveat in immigration law because 101A43U makes an attempt to commit an aggravated felony itself. And so I'd have to look more into that. But it's a big deal. And honestly, the government made the argument, and Supreme Court conceded it. Like, all of this, it was supposed to be a different statute that attempts would become crimes of violence. But the Supreme Court has found all those statutes unconstitutional, including in the immigration context. Sessions v. DiMaia many years ago on 18 U.S.C. Section 16b. So point is that attempts to commit a crime of violence are probably not crimes of violence in almost every state after United States v. Taylor. And oh, by the way, the Second Circuit said as much in USA v. Castillo a week or two beforehand. So 2 cases this month, although Castillo's a bit irrelevant now because the Supreme Court spoke 2 weeks afterwards. I find Taylor really interesting too, because as I discussed on the podcast, there's this whole discussion that Justice Gorsuch gets into about the realistic probability test, which is essentially this whole thing where you can't win even if the statute is broader than a removable offense, unless you can find a case where the state or the federal government are applying it in an overbroad manner. And I'm going to get to this more in a sec, but Justice Gorsuch seems to be saying that all of that is irrelevant and unnecessary, and Duenas-Alvarez does not apply in contexts like this. And Duenas-Alvarez was the immigration case that created the realistic probability test. So I'm not going to get into it so much here. I get into it on my podcast, but there's a lot of language to argue that the realistic probability test is never a sword to harm non-citizens with. It's a shield for non-citizens to use. That's what Duenas-Alvarez was saying, when it seems like they're removable, but they can find a case to show that they're not. It's really been used as a sword most recently by the Fifth Circuit and the board, but you get these bad decisions on it from certain panels from all the circuits all the time, and it's really confusing. I can only imagine the Supreme Court's going to take it up within the next couple of years, because there's currently a circuit split anyway right now. The Fifth Circuit at a minimum applies it differently than all the other circuits. So I think we've got a favorable court on it. So we'll see what happens. So United States v. Taylor, very interesting for all those reasons. Yeah. And I hope you're still following.
I did lose you halfway there, but it's interesting with the way the Supreme Court is, and with immigration, you never know which way this stuff's going to pop now.
Yeah, Justice Gorsuch really does seem to be a friend when it comes to the realistic probability test, and just, you know, the statute says what it says. This is the area where, like, the strict statutory construction that this Supreme Court seems to be, probably for the rest of your and I's lives at this point.
Yeah,
this does benefit non-citizens.
Yeah,
because states write their statutes usually to criminalize the most conduct possible, which is then what you can use as a removal defense attorney or USCIS counsel to show that no, the statute covers too much conduct vis-a-vis the removable offense. So this strict statutory interpretation seems it's a benefit to non-citizens. Justices Thomas and Alito say in Taylor that they want to get rid of the categorical approach entirely, but that's only 2 justices. Nobody else said that.
Yeah. Well, they go a lot behind the scenes. We'll see what happens.
So United States v. Taylor and USA v. Castillo, both really interesting cases. Also, USA Castillo, I'm not in the second, but it's interesting. I was trying to keep note of this. In Castillo, the Second Circuit says that in New York, a criminal defendant can plead guilty to a legally impossible crime as part of their plea deal. I don't know what those legally impossible crimes are, although it appears that that was the case in the Castillo case. But I can only imagine that if you've got a legally impossible to commit lesser offense conviction in New York, that can't make a non-citizen removable. So that's a whole nother avenue that's very interesting to me. If I ever get another New York conviction across my desk, is this one of the impossible offenses? And if so, can you be removable for an impossible offense?
Good stuff. What do we have next?
I just see your eyes glazing over as I speak.
I'm never going to use. I'm like trying to get. Can I use my last name?
Oh, I mean, issue spot. If you got the criminal, to send it to. Not the criminal, the accused criminal. Usually the convicted criminal, but it's.
That's why I said it's your firm. I say contact Kurzban, Titzeli, and contact in particular Kevin Gregg. That's the guy.
I'm really trying not to get into the weeds on it, but I have to. The next one is Aguirre-Zuniga v. Garland, and I just find it so interesting because, first of all, I believe this is the first decision written by Judge Jackson Akuumi, and I hope I said that right. And Judge Jackson Akuumi was on the short list of Supreme Court appointees to replace Justice Breyer. She didn't get picked, but she was on the short list. And so I think this is her first immigration decision now that she's not going to make it to the Supreme Court. And what she said was that Indiana's definition of meth is broader than the federal definition of meth because it criminalizes possession of more isomers. And I don't even know what an isomer is. It's like a chemical stuff. It's his whole argument that federal public defenders and immigration practitioners have been making forever. The Ninth Circuit picked it up like 4 years ago, and then they
having this, learning what the hell this was.
And then they depublished their decision. So, and it's been rejected in the 5th and the 11th recently, but for different reasons. I would argue that it's still alive and well in the 11th, depending, just to create a different factual record. But either way, the 7th Circuit completely on board. Indiana's definition of meth, at least its old definition of meth, I think it might have changed now, covers more isomers, statutory text, the analysis that this Supreme Court loves, that the Federalist Society loves, and it's broader than the federal definition of meth. That's the end of story. There is no realistic probability test. More isomers, federal definition of meth that makes it broader than a controlled substance is an offense, and that's the end of it. And there's a lot of analysis that gets into it, but the Seventh Circuit has agreed with the isomer argument, which is very applicable to both cocaine and meth, and God knows what else drugs.
Mm-hmm. That's interesting.
There was an 11th Circuit decision argued by Michael Vastine and Sui Chung many months ago, which they, of course, did a great job because they're at the forefront of these type of arguments, in which the 11th Circuit said, it seems to me, we hear you, your argument might be right, but you haven't proven to us that actually this isomer exists. Mm-hmm. So if you're coming at it in different circuits, that you're at the removal defense stage, I would say submit an expert report from a scientist explaining to the court what these isomers are. But other than that, you have a published 7th Circuit decision, an ambiguous 11th Circuit decision, and then a completely, we're not going to do this 5th Circuit decision, but we're in. 7th Circuit isomers, big decision. It's, again, Aguirre-Zuniga v. Garland. 7th Circuit. Yeah.
Does that mean people can now do appeals in that jurisdiction, that circuit, challenging their cases and stuff like that? Or,
I mean, if the case is pending before an immigration judge or the board, I mean, floodgates opened. If it has already been decided, it's a motion to reopen, and then there's a whole series of law about, changes in case law are not so fundamental that they require reopening. You're essentially asking the board to do sua sponte, or the IJ to reopen sua sponte. It gets more complicated. We do those motions all the time, and there's other good Supreme Court case law that would indicate that in situations like this, the court must reopen, but it does get a bit more complicated. Certainly not automatic. Mm-hmm. I can only imagine oil might try to get cert before the Supreme Court on it too, if there's not a petition. If there's not a petition pending already.
Mm-hmm. Oh, real cool. So I think I got one more case. How many cases got left?
Yeah, I'm not going to get into the details of it. I just want to mention them for all the listeners. And first, we'll hit the 9th Circuit, as I always like to do on your show. Molina v. Garland. Great decision authored by Judge Paez, all about past persecution for asylum and all the standards about threats, about you have to consider all the threats and everything cumulatively, even for asylum. But most importantly, it is just an outline and a treatise on how to make a Nicaraguan asylum claim right now, filled with country conditions on Nicaragua, and because things are getting really dangerous in Nicaragua. And here you have the 9th Circuit, I believe, because I've been watching the courts now for over 2 years, and it's been like the last 2 years. This is like the first published decision really explaining how bad things are getting if you're a political opponent of Daniel Ortiz in Nicaragua. Mm-hmm. So Molina v. Garland and the 9th is a necessary read, if for no other reason than to know how to really make your Nicaraguan asylum claims. And then back to the 7th Circuit in Menghistab v. Garland, which is kind of doing the same thing for both Ethiopian and Eritrean claims. These deep dives into what's happening in Ethiopia and Eritrea right now, and especially when it comes to Ethiopia, of Ethiopians of Eritrean descent.
Yeah.
And just how bad it is there. Same thing, these deep dives into the country conditions of Ethiopia and Eritrea, that if I was making an asylum claim for such an individual, I would just copy and paste from this 7th Circuit decision, because country conditions, when I'm writing these briefs, you're always fighting against, is this just argument? Are his sources reliable? And I do my best to really rely on the Department of State and then reputable sources, but the Department of State rarely says much. And so it's also always this dance. So if you can cite to published circuit decisions describing country conditions, that's huge. Mm-hmm. And so Menghistab v. Garland on the 7th for Eritrea and Ethiopia, and Molina v. Garland in the 9th for Nicaragua.
Very cool. Very cool. I mean, a lot of this is a learning experience doing the case like this. Like, I just find sometimes learn a lot about how to practice immigration law from some of the decisions, from mistakes people made, and also what they're kind of just telling you what they want. So you could prep the case of the future just like that.
Yeah, I mean, both of these decisions are also heavy on excellent legal standards for representing your asylum and torture convention clients before USCIS or immigration court. But I think that their biggest value is on what they're describing in the country conditions of these countries.
Mm-hmm. Well, one note I got to make is, we've talked about this case the Supreme Court decided, I don't know, a year ago almost probably now, about whether travel on advanced parole with for TPS considered admission and kind of stuff, or their TPS admission. There was a matter of ZRC that was that's taken away. Just the Biden administration said that they're going to issue some sort of new travel document for TPS holders that's different from advanced parole, which will act as admission. So it does solve that, and so that's interesting. They just bypass it. Okay, we'll do another thing. I'm guessing that probably someone's going to sue on it, but that's going to be an interesting thing.
I don't know who's going to sue, though. I mean, I don't think the Sixth Circuit, for example, came down today saying that the states the states of Texas and Missouri didn't have jurisdiction to sue against the PD. They didn't have standing to sue against the Biden administration on the PD memo. I don't know who says standing to sue on matter of ZRCC's revocation. Also, that's a pretty heady legal issue. I know Mark Prada was operating in that space substantially, as were a lot of people. And as have we in the past as well, actually. And USCIS I haven't done as deep a dive into it as maybe I should have, but Ira Kurzban has, who is a founding partner of the firm I'm at. And, I just say this because I don't want to take credit. I like giving credit where credit is due, and Ira always deserves so much credit. But this is bigger than ZRCC, because in that case, and matter of Arabelli and Urabelli, however you say that old case, this is a complete overhaul of what leaving and coming back with TPS is. It's not advanced parole as it used to be adjudicated before USCIS. It's an inspection and admission under this weird statute from the early 90s, as you mentioned. It's an admission. It's not a parole. And so this is like a whole new thing that I don't think anyone's ever dealt with before. And the USCIS is going to issue this guidance. Either way, it gets the TPS holders who've traveled to the same end result, that is adjustment, if they're eligible based on a family member, although it might have different consequences based on whether they're an arriving alien or not, such that USCIS would have jurisdiction if they have a removal order. But that's a whole,
gets popped in my head, because if the admission happens, there's immediate relative cases. A lot of marriage cases are going to have this. But then again, there's INA 245K, which for employment-based cases, EB 1 through 4, says that if you have an admission, it cancels out the previous violations. And from admission on, you could adjust. So all of a sudden, all these TPS holders potentially could do perm and get a green card, if I'm reading it right. Because for 245K, previous violations don't count. After the new admission, so that's going to open up even more than just immediate relatives for a lot of these people, because they probably here have EADs. All these employers could then just do the perm process, get the readmission going. So that's I got to think about as much pops in my head, but potentially it could open up a big employment-based contingent of TPS adjustment cases.
Yeah, no, it's a huge deal. I think we need to wait, and hopefully they make their guidance known soon, so Ira can include it in his book. But I know, and now I'm just straight up advertising for Ira, I know personally that he's already updated the section in his book because he's sent it around to the firm. So buy his next edition, where you can get all of this explained. And it's complicated. Of course, it's not just this, it's everything.
When sorry, my internet's being a little slow. It has a new one come out, or is it coming out this summer?
Not this summer. I don't know when it's set to publish. I know that Ayla, for example, because Ira works very closely with Ayla on publishing this book. Ayla is actually the publisher, I believe. I think you can get, if you purchase by maybe actually, I don't know. There's something if you purchase by the end of September. I think it's coming out in the fall or the winter.
Yeah, there's some early bird stuff, so it's coming out. Because I remember it's already 2 years, but it's I remember getting the Ayla notice that it's coming out or something. Yeah. Well, real cool. That's definitely something to check out and get that update. And damn, it's just so many updates. It's so overwhelming.
He's a maniac. I don't know how he does it.
It's kind of daunting, making a decision to become an immigration lawyer. So many people think it's just forms. And then you get into it, you're like, oh my God, there's 1,000,001, if not 5,000,001 things you got to know. But, you just build on over time. You listen to podcasts like this, and the knowledge just keeps accumulating. And even with Ira, Ira probably wakes up every day and finds something new, even though he's constantly, he's 10 times more eating, breathing immigration than I am. But for anybody, even like Ira, he wakes up and he's like, oh, there's this whole new thing. That you got to sit and analyze. It's too broad and changes every 5 minutes at this point. What an unwieldy area of law, but it makes it exciting, I guess.
It's been rough for him the last 4 years because think about it. Forget about all the regular stuff. He had the Trump administration trying to overhaul everything. And so
Yeah,
that all had to be included in the last book. And now you have the Biden administration really trying to take back a lot of what happened. So now he's got to just delete all of that and amend it for this edition. So I think it's been an exceptional 4 years. And I don't have to tell you that. You know that without even knowing about Ira's struggles making the book up to date.
yeah, it's this stuff's really about passion. You really like the practice area to do what I was doing. It's you don't just do it. It's not a money thing at all. And really, at that point, to keep doing it, it's all about it's just such an interesting practice area. I'm very blessed to have this opportunity. Well, Kevin, thanks again for coming on the show. We'll see you again next month. Definitely check out the Immigration Review podcast and check out the Immigration Lawyers Watch magazine, where Kevin or one of his colleagues at his firm is going to have an article in the next one. So it's happening, guys. The ultimate article is coming soon to a PDF near you. But stay on the line. We'll talk a couple minutes afterwards. But everyone, be safe. Talk soon. Bye bye.
Thanks, John.